This is my speech before the Iowa Medical Board on August 28th, 2013. The Iowa Medical Board is taking public comments on whether or how much it should restrict the webcam abortions in Iowa. The Iowa Planned Parenthood has pioneered this system where, in order to give RU486, the morning after pill, to people in rural communities without an abortionist, why they just set up a little room with a webcam, and they can talk to a doctor that's 200 miles away in Des Moines, and the doctor will ask a few questions and get a justifiable answer for him to press a little button, and then a lockbox opens up for the patient to take out this pill. Webcam abortions are called, and my speech talks about more than just, it doesn't even talk about webcam abortion specifically, but it talks about the legality of abortion in general, and talks about how a court challenge to any ruling taken by the Iowa Medical Board could actually become a case in which issues could be brought which would challenge the legality of abortion in general. So now that's the introduction. Now here's my speech. An event on abortion's legal landscape 9 years ago raises doubt whether courts will recognize the legality of abortion in general if the right case ever forces them to address this event. This is indirectly relevant to the issue before you today, because I think one of your considerations is that if you restrict video cam abortion too recklessly, you could find your ruling challenged in court, in the hope that abortion's legal untouchability in general reaches out all the way to today's brazen form of it. Therefore, if you see that there is a strong deterrent to any such liability, that could affect your vote today. The legal argument I will explain is not only such a deterrent, but if your ruling is challenged in court, and this argument is raised either by you or by amici, not only is webcam abortion likely to be ruled illegal, but abortion in general. A 2004 federal law established what Roe said must be established for legal abortion to end. Roe v. Wade had said, "The point at which the fetus became recognizably human is when a person came into being," and 18 U.S.C. 1841d legally recognized all unborn babies as human, as members of the species Homo sapiens. Roe also said, if this suggestion of personhood of unborn babies is established, the case for legalizing abortion, of course, collapses, for the fetus's right to life is then guaranteed specifically by the 14th Amendment. Lower courts have put words in the Supreme Court's mouth, saying Roe doesn't allow a state to restrict abortion by merely establishing the unborn as persons, but SCOTUS has never addressed that question. And federal law is a stronger basis for national policy than conflicting state positions. Federal courts conform their rulings to federal law, at least until they overturn, which won't happen to this law, which, along with several state laws, have survived dozens of challenges. This question is ripe for review, especially since no American legal authority has ever dared say any unborn baby is not human. It is so obvious, if unborn babies are human persons, that the 14th Amendment protects the right to life, that Roe said, of course it is true. As Roe's claim of uncertainty, whether unborn babies of humans are humans, falls, no replacement sophistry will keep abortion legal. There are questions about some of the wording of this federal law which should never have confused pro-lifers familiar with the law. They're addressed in this document, which I submit into the record and which is posted at saltshaker.us. Click on abortion, and then on the article, No Greener Light.